anybody, so for people that can see this afterwards, I want to thank you all. I mean, the issue regarding um, virtual instruction in the schools with COVID running rampant has really scared a lot of families, and I'm sure it scared, those that are sitting in on this particular meeting. And we're going to talk about that. We also have some news that revolves around some of the machinations that have been going on regarding court cases regarding masks. In fact, I'm going to ask everybody to be muted right now, and then we'll open it up later. Probably the best way to ask questions is through the chat, so that we all aren't jumping all over each other when we talk. The first news is first of all, I want to introduce everybody. Okay, I have Pat Freeze, who's an advocate with my group, with National Art IEP Advocates, NARDA.org. And she's a wonderful advocate. And also, I have with me Danielle Garza, who's an attorney with Sekil and Associates in Austin, Texas. Behind me is Sandra Kaplan, who's also an advocate that works with our group. But anyway, so we're going to start tonight with a little news regarding the mask mandate. And,
a little great news.
A little great news. As a matter of fact, Pat, I'm going to let you go for it.
Actually, yes. Lou and I are also associated with the Southern Center for Child Advocacy, and the Southern Center filed a suit against the governor over his mask mandate. And what we asked was that the independent school districts be allowed to make their own decision about whether to mandate masks or not, because we believe that each district is in a better position to know sort of what the climate is in their specific area. And so that was our what we asked for. And of course, the governor didn't like that, and there were hearings on that case, and then HISD filed their own case, and other individuals filed similar suits. And so there were, last Friday was hearings on all of this. And so we've been waiting. It got appealed, right, to this, is that the right word, Danielle, to the Supreme Court of Texas. And I'm going to share the screen with you. We literally, right when we were, quote, going on the air here, got great news that, here it is, if you can see it, the governor's petition for writ of mandamus is denied, and the governor's emergency motion for temporary relief was denied, which means, Danielle, what does it mean?
That means that that stuff stays, that it's still live. We're still arguing about that. Go on.
The injunction. Sorry. No, there's the injunction. So right now the governor cannot mandate. He cannot tell the districts that they cannot mandate masks, right? Is that right?
That's what I'm reading it right now.
That's correct.
Paxton stepped in and filed this writ of mandamus. There's a bunch of these kinds of cases out there, arguing about state versus local authority. DRTX has one. Yeah.
Right.
Yeah.
Disability Rights Texas, yes.
Usually in a case of an injunction, correct me if I'm wrong, Danielle, is that there's a likelihood of success when it actually is heard by that particular court, like a temporary TRO. Is that true or not true?
It's short answer is yes, but it's not like a guarantee. That's not like a look. Here's a look. So yeah, we're gonna rule in your favor.
Well, at least that there's enough that they want to go forward and the hearing, but that certainly is something positive for them to approve the injunction. Would
No, I
you
mean,
agree
yeah,
with
because
that?
the injunction is stating that there's going to be irreparable harm done for folks if they do this before we settle these cases.
Right.
And
Someone's asking, sorry, what's the news? I hope you got it, that we filed a suit to stop the governor from mandating, from refusing to let school districts mandate masks. And that has been, what's the legal word, Danielle? I'm going to let the lawyer tell us in legal terms, but we won. Yes.
there's a multi-pronged fight going on about the governor's executive order that precludes districts from prohibits them from doing these kinds of basic COVID prevention protocols like masks,
Mhm.
period. He's just saying you can't do that. And there's some arguments about the division of state and local authority. And it goes back to like an old disaster act from the 70s that they're referring to now in the current COVID-19, pandemic that's going on right now. We've had school districts, counties, and other entities file these kinds of things. And they were requesting an injunction to stop his executive order from coming into effect while they hash this out in court. The lieutenant, I mean, the
AG.
AG, Paxton, stepped in and filed that mandamus with the Supremes, the Texas Supreme Court, to cut off the injunction, and they denied his request. They didn't rule on it. They didn't rule on the merits. They just denied it.
Yeah. Yeah. Well, that's still a huge, that we didn't really know where we were on that, but that's at least one small victory until the big dance. So
Yes, and the hearing is going to be August 23rd, 24th, 25th, somewhere in that
23rd through the 25th. That's
23rd to the
correct.
25th.
So
yes.
anyway, that's kudos to our friend Hank Bostwick
Yes.
for the Southern Center for Child Advocacy, who had been one of several attorneys that had filed on that for that injunction. So what that means is they got to keep the if school districts want masks in the interim, they're going to have to be masked at least until the hearing. So that is great news
Yes.
for our kids.
Thanks for joining us, David. Hey, I see you came in.
Dave. Hi, David. You got a pointy head there, David. There.
It goes all the way up to the sky. Oh, wait, what is
I see that. So anyway, what we went with, before we went live on this tonight, we didn't know what the Supreme Court was going to do, the Texas Supreme Court was going to do about the injunction, but that still doesn't mean things are over yet. So many of you are having concerns about what happens with my kid, because the districts have said, oh, well, you've got basically two options. You're either in person or you're receiving homebound services from the district, essentially. And, and so the issue is, many of you have kids that are immunocompromised, or they're of high risk of complications if they were to get COVID. And so what this seminar, discussion is really related to what happens in that situation. What are number one, what is your course of action? What can you do and to protect your kids? That's really where I would start the discussion. Okay?
right? And I think that because for the parents that have joined us, if you are in that situation and you have a specific question, please feel free to put it in the chat. I'm going to read it to Lou. Here's one. We've got one right off the bat, Lou. What can I do if the school district and the majority of the parents don't want, well, hang on here a minute, don't want masks. My son is in middle school, but does not qualify for the vaccine. Plus, he received accommodations for ADH neurological delays. But the district is not offering virtual for middle school. This is exactly what we are talking about. And what is, do you know what AS is? That autism, or are you talking
Autism spectrum
Okay.
disorder.
Okay.
Okay, well, the first thing is, number one, I mean, has the doctor I would still think that a physician would still have to weigh in some way to determine whether whether your child has some type of, is either immunocompromised or has a risk of complications because of their of their particular condition if they were to get COVID. It would be important for the physician to weigh in on that because failing that, on what grounds would you say, well, I don't want my kid to get COVID? The issue is if it's severe enough where it would cause a problem, and it would also possibly cause their possibility of them of them getting so ill, or the parent not wanting the kid in there to be at risk. Now, Danielle, if you want to weigh in on that and chime in,
there's also elements about whether the kid is capable of complying with the protocol, depending on their disability. But you're going to be presenting all these things to the art committee and requesting those kinds of services. They're going to have to say no. If they say no, then you go from there to the filing a due process. But I mean, as far as the steps on the ground for what you're going to do, I mean, you got to ask for the service. And if you're not comfortable with your kid going to school, I mean, that's a family decision that's made outside of the context of whether it's good for your case or not.
We discussed this earlier, and it seems that if your child has, for instance, asthma or some, I don't know, some other cystic fibro, I don't really know, some kind of lung issue where, COVID would be particularly dangerous. I'm of the personal opinion that COVID all by itself is dangerous enough for any child, but that for a child who doesn't have an IEP, and you can't go to the ARD committee and plead your case. In this case, I don't know how severely affected your child is by autism, but ADHD could mean that your child can't keep the mask on, can't keep his hands, there could be some concerns for that. And then, so you might be able to make a case to the ARD committee for children.
Even if they're
parents, go ahead.
Even if they're not somebody that the CDC has identified as like a condition that's at risk for severe COVID infection, they're a kid that's not eligible for the vaccine.
Right.
And, you lead with that as well.
Okay, so our person is saying, I guess it's the same person, the cardiologist, the cardiologist is a big deal because, neurologist has written a letter to the school that he would be a big risk. He wants to wear a mask, but no one at school does. So this kid's in junior high. Nobody's wearing a mask. He wants to, but he's got these risks, and a letter from the doctor. So is that
that's an identified condition on the list of the CDC list of those kinds of conditions. And we got David on the line too over here. I don't know if he's got something to add to it.
David, feel free to unmute and join us, please.
No, I'm just here to listen. Thank you.
Oh, come on.
Well,
all right.
It's certainly the issue would be, from my perspective, that would have a tendency to it's a matter of this issue overriding is an issue of access. This will impact the child's access to the educational environment. And that really gets to even the Americans with Disabilities Act and even Section 504. If this is such a condition that would prevent them from, being able to, be in school, well, that they're denying them the ability to, for them to have access to the educational environment that's inclusive. I mean, here's the problem.
It's a straightforward claim. This
Yeah.
is excluding a kid with disabilities who's identified by the CDC
Right.
as someone who's at greater risk,
Mhm.
in addition to not being eligible for the vaccine, in close quarters with people who are not following CDC protocols for COVID.
Well, here's let me make my point where I was going with this. The issue is the schools have said you have basically two choices. Your one choice is to go, be in person at school in brick and mortar and be exposed to those kids. Or you would be, I would call the term siloed, where you would have your instruction through homebound. And that has to be signed off by a physician. It has to be a medical condition. And actually, it has to be a medical condition that renders a child unable to go to school for a period of at least 4 weeks, not necessarily continuous. But here's the problem with homebound instruction. The Texas Education Agency has defined, or has basically said to school districts, that 4 hours a week, not 4 hours a day, 4 hours a week equals a full week of instruction. So school districts have said, oh, you're on homebound, you get 4 hours. However, 4 hours where they have a teacher come into the home and work with the student. Now, I've seen TEA has come out with another proposal where they will provide instruction virtually they would basically provide 4 hours. I couldn't tell, is that a week or a day, Pat? Was that a week or a day?
I think it was, I'm gonna pull it up right here, Lewis. I think it was, let me just see. Got it right here. Okay, let me read it. It's on this. Oh, I need to share my screen with you guys. Hold on 1 second.
Now, this is a proposal by TEA. It hasn't been approved yet, but this is a proposal.
Okay. Come on here. Okay, on page 2 of this, right here where it says new as of 8/12/2021. If your student is in pre-K through the 5th grade, they must receive, this is home, no, this isn't homebound. This is what the TEA is calling remote conferencing. And we'll talk about who qualifies in a minute, but then your child would receive the equivalent of 4 hours of instruction with at least 2 hours of synchronous instruction, means person to person, right? And the hours don't have to be consecutive. If your child is
think about that for a minute. So it's 4 hours a day of this virtual instruction. Synchronous mean with a live teacher, and the other 2 hours are asynchronous, which effectively means it's without a teacher. It's like you're on your own. Here's some videos to watch.
Well, let me just finish this thought. So if your child is in the 6th to the 12th grade, they have to get at least 4 hours of instruction through synchronous each day. But I want to talk to you about, well, I got too many things I want to say at once. For students, no, back up. pardon me, let me just get this. I want to tell you let me go to the first page of this and talk about who is eligible or who may be eligible for this remote conferencing. And you can
Pretty
read it yourself,
restricted.
sir.
It's pretty restricted.
Very restrictive, yes.
It is.
If the school district provides instruction through remote conferencing to a regular ed student, and this is for funding purposes, but we can pull information out of it. The student must be unable to attend school because of a temporary medical condition, and the total amount of remote conferencing does not exceed more than 20 instructional days over the school year. Danielle, this is basically what? Homebound,
Homebound.
right?
It's
Yeah.
homebound. It's virtual homebound, but Celeste, you just said what this district had, what had been offering you. The issue is that this is a proposal by TEA that was offered as of August 12th, and I don't think it's filtered down through the districts, but it's still homebound. You call it whatever you want, virtual or in-person homebound, but it's homebound. Homebound is extremely restrictive. It doesn't give the child the opportunity to interact, even virtually, with their non-disabled peers. That is a problem. That is a problem of access.
Homebound's not meant for this. Homebound is meant for kids who are sidelined temporarily because of a medical issue that they're going to recover from, that they're not,
That's right.
they're going to need short term.
And there is another term that we would probably I want to make sure you guys understand. There are two different things, entirely different. Homebound, which is what we're talking about now, homebound or hospital bound, and services in the home or home instruction. The Individuals with Disability Education Act, IDEA, talks about home instruction, and it's quite different. Let me switch over to my notes. Danielle can probably tell you this by heart, but students who receive special education and related services under IDEA are unable to receive FAPE in a less restrictive setting are eligible for home instruction. So would this be something that we would be talking about?
Well, I mean, here's the problem here, okay? It's so restrictive. Like I said, it's no less frequently, excuse me, it has to be a minimum of 4 weeks, not necessarily continuous, right? It's 4 hours equals a full week. They don't give the full range of courses. It's only core courses. It's not electives, okay? They cannot interact with their non-disabled peers. Basically, what they do, either virtually or in person, they basically have an itinerant teacher come to the home and work with the kid. But here's one of the things that's really a problem. The schools say in homebound, you can't go anywhere other than going to the doctor. You are either in the hospital or you're at home, and you can't go anywhere. It is the IDEA never envisioned that in their language. They certainly never put that in there. This is something that a number of states, including Texas, have done to basically go beyond federal law and make it more restrictive, which we believe is an issue.
Well, it's not even a bait and switch. They're just not offering virtual. And one of the things that they are offering is homebound, but it's not a substitute for virtual.
Right. We just had another, hold on just a minute. Let me get back up here. So the parent we've been talking to says the district student services told the parent that the student would have to attend in person or withdraw. There were no other options.
Well, what you need to do is you need to go to ARD and say, look, I want virtual, again, in your case, I believe you said the cardiologist and neurologist weighed in. provide that letter, say, look, that we need virtual instruction. And we want it, where it mirrors the same day through Zoom or otherwise, and we want it synchronous. If they say no, then we talk, then you disagree, and then you go to the dispute options.
Yeah, you got,
We'll
I mean,
discuss in a
you're
minute.
presenting this to them. You're saying this is the least restrictive educational environment for him, given A, B, and C. Here's the doctor letter that supports that need. This is me asking. And, you don't need to spend half the day pleading your case. They say yes or no. And if they say no, you disagree and talk to Lou or whoever or yourself. You can decide if you're going to file from them.
By the way, one thing that's another thing, a problem with homebound, there is nothing in federal law that says as part of an IEP team that a physician needs to be part of the team. That is what they make it. That is what they're insisting. Number one, with this new TEA of these TEA guidelines, as well as being at homebound. The ARD committee can make their own determination from the data that they have in front of them. But absolutely, if you get yourself into a disagreement, then you have options. What kind of? Let's talk about the options of what you have if you have a disagreement in ARD. Okay, one option is you can file a complaint with the U.S. Department of Education, Office of Civil Rights, OCR.
Here you go, Lou.
Okay, there you go. Here we go. All right, well, here we go. Here's some options. Give up, live with the status quo. This is from our good friend, Doreen Philpo. Or you can pull yourself out of public school or private school, go to homeschool or private school. You can pull your child out of public school and put them in a private placement at your own expense without seeking a special education hearing to seek reimbursement. You can pull your child out of public school after giving them at least 10 business days written notice. You got to tell them, look, I'm going to take you haven't provided my child with a free and appropriate public education. I am giving you written notice that in 10 business days, I'm going to take my child out. And you can put them in a private place and let them know that you seek reimbursement from the district.
Right.
Okay?
It's the 10 days notice, yes, that you're going to pull them out, but that you are also going to seek reimbursement. It's a two-pronged, have to include those things in the letter.
And you could give them notice by email, that's fine. But you got to give them 10 days written notice.
Written notice.
10 business days written notice of your intent.
But you do not have to actually pull your child out.
No.
You on the 10th day or the 11th day, you don't have to pull them out, but they have to have at least this notice.
Okay, the next is you can go back to an IEP team meeting as frequently as required to get what your child needs, and you can do it again and again and again. What day is it? I want another meeting. And
they may not try, they may not. I don't know really what the law is about that, but some have said, well, what do you want to discuss that we haven't already discussed? I don't know if districts will go along with that ARD after ARD after ARD.
Well,
if it's a substantive issue, they'll do multiple ARDs if they have to. They're not in the business of having a weekly ARD.
Mm-hmm.
Right.
But if you call an ARD just to spite them, yeah, they're gonna give you a little pushback.
Right.
But there's nothing that says you get one ARD a year and it's at their discretion.
Right.
That's right. You can go
but if you have an ARD meeting to discuss a topic and you don't get what you want, you can't a week later say, I want to discuss that topic again. And then a week later, discuss it again, just hound them on the same topic until you get what you want. That's not what I think. I don't
basically,
think
basically you go to a meeting, you have a disagreement, they give you a 10-day non-consensus, go to that. And if I only give them 1 or 2 shots and then I start turning screws. You can go to ask for a facilitated IEP meeting. That's where a person who's not a district employee but is knowledgeable about special ed matters is brought to run the meeting. Sometimes that's better because a lot of times I see people in these meetings that really don't understand the process. You can go to
Most
meeting,
times.
beg your pardon?
Most times, actually.
Well, I guess that's why we do what we do, right, Pat?
Yeah.
Um,
Job security.
You can go to mediation. Each state education agency has a mediation system of varying quality by state. Here in Texas, it's pretty good. A state not affiliated with a district, a person not affiliated with a district attempts to get both parties together to deal that everybody can live with. Conversation, mediation, or confidential. My experience in mediation, though, usually a district will be more will usually want to mediate once something is filed, whether it's a complaint, where it's a due process complaint, generally doing it without this sort of Damocles to their throat. They usually don't want to do that. It's basically if they have a risk of losing a possible decision from some third party, that may motivate them more to mediate. That's been my
Yeah,
experience.
what Lou is saying, if they don't see some kind of exposure, they're going to be not as inclined to do mediation. Now, it doesn't mean they won't, or it doesn't mean that it's a requirement that you file a due process, request for a due process hearing, but you're much more likely to go to mediation. If you do that, if you disagree at the ARD, you might, request it at that point. I mean, sometimes that might be enough of a, carrot and stick kind of combination to get them there. But, Lou's correct. If they don't feel some kind of pressure, feel some kind of exposure, they're less inclined to enter mediation.
But they don't have to mediate with you.
No, they don't. Neither do you. And you don't have to agree at mediation.
Mhm.
I mean,
This is not arbitration, it's mediation, and both sides, it's a voluntary basis on both sides.
Mhm.
But the mediators are paid for by the state.
Right.
no dog in the hunt.
Yeah, and so you can file a written complaint with the TEA, the State Education Agency. Sometimes that'll give you traction. Or you can do the nuclear option, which is you can file for a special education due process hearing with your state, with the TEA. Hearings are governed by the IDEA, Individuals with Disability Education Act, 2004. Education Improvement Act, excuse me, of 2004, IDEA 2004, and all its implementing regulations. Again, a lot of times if you file under an IDEA due process case, the districts a lot of the times will want to mediate with you. And if they if they want to mediate with you, most of the time they want to deal. Most of the time those will end up in some type of a settlement. Your other options, I think that was one of the first ones I mentioned, was the Office of Civil Rights. Basically, if you get $1 of federal money, you cannot discriminate on the basis of disability, religion, sex, or gender, or gender stereotypes, age, or national origin. You just can't do that. And basically, the U.S. Department of Education has a division inside the Office of Education, the Office of Civil Rights, and what they have is a neutral fact finder that you file your complaint, you give them the evidence in that complaint, and then the district will respond. And long and short of it is, the only problem I have with OCR, sometimes you get some good results, but my experience with OCR historically is that they take forever to get through a complaint. And right now, this is something that's hot, this is something that you want rectified now. This is something that you can't have the kid out of school for a month, 2 months, 3 months, or even longer. I've seen OCR complaints I've seen OCR take a year or two before they even give it, or longer, believe it or not. You can also file a complaint with the U.S. Department of Education Office of Special Education Program. The acronym is OSEP. You can go to OSEP's website. Sometimes one of the things they do is sometimes they'll do an interesting investigation. Problem with that is sometimes they take a long time too, but that can be effective if they'll take the case.
Yeah, if they take the case, the district is not going to be happy with having OSEP in their business.
Yeah, that's like the IRS, wanting to look into your stuff. That's the IRS to the school districts. Okay. You could relocate to residents to another district to get
Well, in
a.
this case, it'd have to be another state, Luke, because
That's,
Texas
yeah.
is Texas,
Yeah,
right?
that's not gonna, yeah, well, at least we've got this, at least we've got the injunction, which.
Yeah.
They're not mutually exclusive because one approach means you can't do another. Always ask for your student's educational record. Also, if there's, well, this isn't really as much of an issue, I guess, with an individual staff member. You could do an internal grievance with the district. That is one option. And generally, it's a 3-step process, starting with the principal. And you basically tell them what the issue is and what you want done about it. And it goes up the food chain. Many cases, they can be appealed beyond. It goes from the school. It goes from the principal to the superintendent's office or their designee to the school board, and a number of scenarios that can also even go all the way up to the commissioner of the TEA. That's an interesting thing when it goes to the TEA, because there isn't as much precedent in the decisions that the TEA commissioner does versus what you find in the courts. But that's your array, of things that you can do. Yeah, Danielle, you want to jump in on that as an additional issue? I think we were talking about one more option in this particular case.
Well, we were talking about federal lawsuits and injunctions and all that manner of stuff. And at this stage, folks that do what David and Lou and Pat and I do are hearing all kinds of complaints from all kinds of different places that might end up supporting kind of a mass filing on this issue. I'm not sure if that's where we're going on this yet. I mean, we might be able to establish a class and push this forward. At this stage, we're at the early stage right now. We're seeing how districts are responding. This is new to the district. I mean, folks are requesting services that were being offered a few months ago.
Mhm.
So we know they can do it. I mean, we had lots of beefs with how they were doing it. But they were doing it. And if they're doing it a little more coordinated and there's some actual support, then, maybe we could build on the past work that they did before.
Well,
I mean,
the
there's
infrastructure's there, right, Danielle? I mean, it's there.
there is a whole lot of money, emergency relief funding for schools that were specific for these kinds of issues. Funds that were specifically laid out to develop strategies and protocols in line with CDC recommendations and guidance. And there's been there's all the drama with Lou was just saying we have a quorum now, so it's possible that that funding bill that was on the hook directly related to this, kind of the one that followed the earlier 2001, I think it was at the ARP Act, American Rescue Plan. Am I making that up, Lou?
I can't. I'm not certain on that. I'm sorry.
Anyway, but it was the act in early 2001 that allocated all those billions of dollars. That was going, like, they characterized it as emergency relief funding for schools, for school districts, and it was specific and it was explicitly authorizing them to use those funds for developing those strategies and protocols. Virtual, what we're talking about right now.
Mhm.
And, schools are complaining that I think one of the main drivers behind this is that providing virtual is different if everything is shut down than it is providing virtual while the campuses are open also.
Mhm.
To do that, that would require some more, they would need to spend some more money. They would need to have some more people on board to support that effort. You can't just expect, a teacher to be teaching to the class and to the virtual class at the same time, especially with multiple IEPs that are going to be involved in it. It's just untenable. So I'm saying that they can't just say no because it's expensive. We know we've done it before.
Right.
We can allocate some of that money to this instead of just putting up a block and denying people, who have a right to something access.
Okay,
Right.
so at this point, okay, I mean, I think we've laid out the
I
issue.
have a couple more comments before
Go
you
ahead.
wind up.
Okay,
Okay,
no,
sorry.
what I was gonna do was ask for some more comments from from our listeners. So go ahead.
Okay, so this person says the CDC says that most people with developmental disabilities are not naturally at higher risk for becoming infected with or having severe illnesses from COVID. However, people with developmental disabilities who have serious underlying medical conditions may be at risk of serious illness. Some people with developmental disabilities may have difficulty assessing information. It's hard because the type is like squished in. Assessing information, understanding, or practicing preventative measures, and communicating symptoms of illness. So autism qualifies as risk medical condition. So we can get virtual. So can we get virtual or homebound? Did y'all follow that? Sorry about that.
That was what that is the part of what you're pitching to the art committee in support of your request for homebound.
Mhm.
That you're going to argue that they fall into the category of folks that the CDC has identified as having higher risk factors for severe COVID infection or for what's the word I'm looking for? For
Immunocompromised.
yeah, or for worse outcomes
Mhm.
because of it. And I mean,
So
they've specifically included like heart conditions, cerebral palsy, Down syndrome, immunocompromised, but that's not an exhaustive list.
Right.
And I think
so
that
those parents could use that and go to the art committee and say,
I would make it a little bit more brief, but yeah.
Mhm.
Like you're making an elevator pitch. It's like we need, virtual because A, B, C.
uh-huh,
Here's the letter from my doctor that says so.
right, right.
But I mean, you can't like bust into a soliloquy about it and expect them to listen to you.
Right,
Right.
right. It does need to be succinct. And so, parents, you are your child's first line advocate. And if I'm not pitching to get business, but if you're not comfortable making that case for your child, then you should have an advocate, someone who can make that case for you, go with you to the ARD meetings, make the case for you.
You guys are already writing it up ahead of time. That's a big deal. And if you have to read from a piece of
Mhm.
paper or a cocktail napkin or a Big Chief tablet or whatever, fine. I
Right.
mean, it just helps you keep it in line. And
So-
it's in your natural voice. That's what they want to hear anyway.
Yep.
Distill that a little bit and you make the request and then we go down the list of the stuff that Lou and Pat were describing earlier.
Okay, so I want to put it, did you want to say one more thing, Pat?
Well, yeah, I don't know if it's the same person, maybe different. And you might want to, again, speak to this difference in homebound and instruction in the home for this person. Before COVID-19, our daughter was approved homebound services due to emotional disturbance. Her school environment was the cause of her anxiety. Her doctor made the recommendation to the 504 committee. Okay, that's all of that.
I don't know why she's.
Um,
So
entitled-
homebound for anxiety?
Well,
Does
why
this
not?
person, whoever wrote it, do you want to just unmute and talk to us about this? Go ahead if you want to.
Go ahead, we'll talk. Go ahead and unmute if you want to talk about that case. We'll talk to you about it.
I think they may be typing. Because I'd like to explain to you, if you weren't on previously, the difference between homebound and services in the home.
Yeah.
Well,
Okay,
So,
I mean,
That's all right.
they might need to consider whether they qualify for special ed services.
well, that's what I was saying. I don't.
Emotional
understand-
disturbance.
Well, yeah,
Yeah.
I don't understand why they're not qualified under SPED. The problem under 504, while I still think this is an IDE, I still think this is an ADA issue, and even 504 should give you the opportunity to have instruction, virtual instruction with your general ed peers. I think you still have some weight there, but
Yeah, they overlap on the Venn diagram as far as access, all of those.
yeah.
The Zoom, this person cannot unmute their mic. Luke,
Okay,
can
would you
give them
like, if you
permission?
want to go a little deeper and then you want to type it? Yeah, okay, Ms. Soto, do you want to go a little deeper in your question for Zoom and for the chat, and we'll take that up. We'll answer that, okay?
Pardon me.
In the interim, if there's anybody else that would like to have any other questions that we haven't addressed, please, by all means, feel free. Oh, okay. Let me see what I can do here. I need to enable you, huh? Okay.
Oh, you have more power than you thought you did.
Okay, let me see what I can do for you. Let me see what I can do for you.
Yeah, I mean, these things that we're talking about, once we get specific about one person, it's not necessarily applicable to everybody, but it's the same issue. I mean, access is the issue, and that's the terms that you're couching all of your requests in. It's like, this is keeping your kid from accessing services to which they're entitled. You figuring it out there, Lou?
No, well.
I want to show, if anybody's interested in looking at this TEA document for yourself, I'll just, you might want to Google. It is, just a second. It's the TEA. Go to, just Google TEA and remote conferencing, and FAQ stands for frequently asked questions. So you can read the whole document for yourself.
See what I can do. I guess I could make you a co-host for a second. Ms.
Go
Soto,
ahead.
See if that does that.
We've
Yeah,
about covered everything.
We could use one.
Okay, so you understand the difference between, so help me with the question though. If you understand the difference between homebound and virtual, I mean, what's the question that I can help you with? Want to find that?
I'm guessing she wants to upgrade